Good morning. We're very pleased to see you, Mr. Stark and Ms. Caney. Thank you very much for your preparation and the way the paper case has been put together. It's been very helpful. We're being live streamed. Are there any preliminary applications we need to do before we get on to the merits?
My lord, there are two issues, I suppose, before the court. One where there is an objection raised by the respondent to us refining our definition of other status down from the argument before Mr. Justice Cotter, which concentrated on capacity by reason of ill health.
Yeah.
Refining it to the question of, well, if there's an objection to that, then that can be met by refining it to disability.
We're aware of that point. What's the second point?
The second point is a point that's taken for the first time in the additional reasons by the respondent, and that is what might be called the independent existence point, arising from the line of authority from Cliff to Doherty about the case being such that a status cannot solely be defined by a difference in treatment itself or a description of the difference in treatment itself. I'm able to deal with that point.
Can I tell you what? We think, we've talked about these issues, rather than have a sort of legalistic argument about what is and isn't a bit, can we hear the argument and then see where we are? I know that sounds a bit fudgy.
Well, indeed, my lord, I was going to suggest that to answer those questions,
You've got to hear the argument.
Hear the argument first.
Okay. Happy with that?
Indeed.
Well, very sensible. Okay. Have you had a chance to talk between yourselves about the division of time? We have all day. I don't know whether we'll need all day. Have you had a chance
Yes,
to
I think
talk
the
about
proposal is that I will make submissions until 1. I'll learn a friend then from 2 till 4, and then I'll reply shortly after that, unless the court.
it? Okay. No? Well, that would...
Yeah.
That's all we've got, so we can't have more than that. Maybe it won't take as long. We'll see how we go. Obviously, now we've read, I think, the key documents. Okay, so we've read the judgment, we've read your helpful skeleton arguments, we've dipped into the authorities. Some of us are more familiar with the authorities than others. You'll appreciate that, Mr. Stark, but we've dipped into them. So we think we've got a pretty good idea of the issues of the case.
I'm grateful, in which case I will probably open less on the facts than I might otherwise have done.
Well, the facts are quite... We could spend all day telling us about the facts, but I think we're pretty clear on the outline of the facts.
I'm grateful.
Yeah.
Yes.
Yeah.
So the fundamental question for Ms. Mailley, the defendant in this case, was one that we outlined, which is that had her mother died when they'd been living together for more than a period of 12 months, and of course they'd actually been living together for over 50 years at home, then she would have succeeded to the tenancy. Had her mother had capacity to assign the tenancy, and that's whether one puts that on the basis of capacity itself or capacity as a consequence of disability, a lack of capacity as a consequence of disability, then the tenancy could have been assigned to her. But by the time her mother came to be required to leave home, and it was on the basis that she could not continue to live there, firstly because of the arthritis that she suffered that meant she had to be turned every 2 hours, and it was impossible for that care package to be funded at home. And the second was her dementia was also deteriorating by that time. She was placed into respite care for a while, and then it was decided in October 2016 that had to be permanent. There was no longer what is described by the authorities a real possibility of her returning home within a reasonable time.
And there was a lasting power of attorney, but that was in favour of your client.
Yes, so she couldn't exercise it in favour of herself.
Do we know, Mr. Stark, at what point the tenant lost capacity? Is there a finding about that in the judgment?
No, there isn't a finding of that in the judgment. So far as the condition of the vascular dementia that she suffered from, it was a progressive condition. I think evidence was given about starting to manifest itself because she couldn't recognise characters in television programmes and remember what was happening in matters like that. So things began to worsen.
Were there capacity assessments?
No. The only capacity assessment really that was undertaken was the one undertaken, as I understand it, at the time in October 2016, that the decision was made that she could not go home.
But that was focused on her physical state.
Primarily, it was based on her physical state. There were also references to concerns that her dementia would accelerate if she had to go home.
Capacity is issue specific under the Mental Capacity Act.
And it's assumed.
And it's
one-
presumed under Section 1.
Yes, it's assumed that one has capacity until it's shown otherwise.
Yeah.
Yeah, it is. And it is, as the authorities show, issue specific. So it doesn't look to me as though, for my part, there was ever a capacity assessment on relevant to this issue. I'm not sure whether that helps either way, but as a
No,
matter of
but
fact.
there was a notice to omit facts served in the course of the
Yeah.
proceedings below, and the local authority admitted that by reason of her dementia, as at October 2016, she did not have capacity to assign the tenancy to her daughter.
And there's no suggestion there. There's a lot of talk in the judgment and also in the authorities about capacity coming, fluctuating capacity, as we call it in the Court of Protection. But there was no suggestion in this case on the facts that this was a case of fluctuating
Indeed.
capacity. And your point is that's not consistent with the sort of dementia that she was suffering from.
Yes.
Yeah, well, got that. Yeah.
So that's where the difference arises in this case. It arises from, we say, the fact that instead of dying at home, she had to leave home because of her ill health or disability, which you put it, and she was not able to take the other step by which you can assign to a qualifying successor under Section 91(3)(c) of the Housing Act. So it's not as if it's entirely a question of being a successor and awaiting for someone's death, because Section 91(3)(c) of the Act, the Housing Act 1994, specifically provides that you may assign to someone who is a qualifying successor. And that is only one of three narrow exceptions to the general rule, which is you can't assign a secure tenancy at all. The others are assignment in the course of various matrimonial proceedings or under the Family Law Act, and by way of mutual exchange, which is when a tenant will, at number 7, may want to exchange for someone at number 21.
Is there any reason why there couldn't have been an assignment to the tenancy at some point before October 2016?
Well, no, there's not a reason in the sense that that she didn't, in the sense that obviously for a significant period of time when they lived together that she did have capacity. But one thing is that is certain, or we say, is that tenants don't necessarily know their rights in relation to their ability to assign to other individuals. Indeed, in the tenancy conditions in the supplementary bundle, appear only really to look at the position in relation to post-2012 tenancies, because they say you can assign potentially with our consent, which may be what the tenancy conditions post-2012 say. I haven't seen those because they obviously don't relate to this tenancy, because it was a tenancy that predates the 2012 changes brought in by the Localism Act. So it isn't necessarily the case that tenants are aware of that ability, of that possibility of assigning before that time.
But I think the judge did find that they did make inquiries about whether or not the defendant could become a joint tenant.
Yes, that's right. Back in 1998, I think it was, they inquired and asked whether or not she could be joined as a joint tenant. The reply to that was that their policy said that only if she'd been entitled to a house herself as a single person. It didn't inform them at that time of the alternative possibility of an assignment from mother to daughter. But it could be said, well, they didn't ask about an assignment, so that might explain that. Equally so, it could be said that it might have been helpful to have given them all their options at that time. But the point we say is it's the opportunity's been lost by the loss of capacity to assign the tenancy to their daughter at that time. And it's the fact that that coincides with the effects of the disability requiring her to leave home. That she had to be removed to firstly respite care and then finally to a care home. She could not continue to stay at home. So obviously there may well be situations, a lot of situations, where someone who suffers from dementia still dies at home. or may go into hospital and never enter residential care. And in both of those situations, they would be treated as the property remaining as their only or principal home. The question is the Tickner and Hearn question, as I put it. That's at tab 9 of the authorities, for the local authority to ask itself. And it's a question that a local authority has to ask itself very regularly, not just in these circumstances. In that case, it's page 25 of the book, it's the headnote. In that case, Mrs. Hearn had been living with her daughter. She then went to stay with another daughter, and when staying with her, she suffered it was described in the language of the time, a nervous breakdown, was admitted to psychiatric hospital, and was diagnosed as suffering from paranoid schizophrenia. The daughter remained in the premises for, I think, 5 years or so. The landlord then sought proceedings in December 1959, being a landlord by purchase, on the basis that the Rent Act no longer applied because Mrs. Hearn was no longer occupying as her residence. A similar test to only principal home. But the Court of Appeal upheld the judge's refusal to make an order for possession on the basis that, having heard evidence from the psychiatrist responsible for her care, it could not be said that there was not a practical possibility of her returning home, because she'd become a voluntary rather than a compulsory patient. And although they may well at the current time wish to persuade her not to go home, there was nothing at that stage stopping her from going home. And Lord Justice Wilmer said, at page 33 in our bundle, I've not forgotten the view of Dr. Russell. It is most unlikely she will ever fit enough to leave hospital. As pointed out by the judge, it is quite impossible in this case, having regard to the improvement already achieved and to the advances which have been made in methods of treatment, to rule out the possibility altogether. Had the evidence showed that in no conceivable circumstances could the tenant ever hope to leave hospital again, a different, and as I think a difficult question would have arisen. And that question then is, there's some argument about on who the burden of proof would lie in that circumstances, but that doesn't really concern us. Then Lord Justice Upjohn, over the page at page 34.
None of this is in dispute, is it? Nobody suggests that there was a conceivable hope of her returning.
No,
Do they?
no, but the point I'm making is that in relation to the test that the local authority has to carry out,
Yes.
when deciding whether or not someone has ceased to occupy their only principal home in these circumstances, this is the test that they must apply. So
And that's agreed, isn't it?
yes, it is.
And that was the test they applied. There was
Well,
no conceivable hope from
yes.
October 2016 of her returning because of her osteoarthritis condition.
Yes, combined with the dementia. Yes, that's right. That is the test to apply. But the point is that I'm seeking to outline this is any suggestions that this is going to be a very difficult exercise for a local authority to carry out when faced with someone in this position, as to whether or not the conditions are met for what we say should be read in to section 87. So the first question for the local authority was going to be this one. One local authorities have been used to dealing with and answering for a very long time, has been set out in cases for a very long time.
And you accept that the answer was the inevitable answer that the local authority gave?
In this case,
Yes.
Yes. Obviously, there may well in certain cases be matters of dispute, matters of discussion, but that obviously in certain relation to the conditions that the late Mrs. Mailley had, it led to that there being no alternative for her to stay in the residential home. But it's noticeable that she was, of course, originally admitted for respite care.
Mhm.
So at that stage, that was obviously on the basis that they wanted to carry out an assessment as to whether that was possible or not.
Yeah.
So what we say is that the difference between someone whose parent who dies at home and who dies in hospital potentially from the same conditions, is that she ceases to occupy, not out of choice, but because of the consequences of those conditions, that she had no alternative but to leave her home with 50 years and to go into care. So had her mother died at home from the same conditions, or died in hospital in the same conditions, she would have been entitled to succeed to tenancy. The difference in treatment arises from the mixture of the cause, the time and the place of her mother's death.
Sorry, the difference in treatment?
The difference in treatment in that sense arises from characteristics of her mother, namely the cause, the time and the place of her mother's death.
Doesn't it arise from the condition in the legislation that you must have the property as your only or principal home?
Yes, but the condition ceases to be met because of the identifiable characteristics that she has. Just as, for example, in the TP case, the condition that the person had to remain in a particular area to continue to be entitled to housing benefit because of universal credit, where they would then receive less sums. If they had to move border into another local authority, then they had to claim universal credit. You could say, well, that comes just from the legislation. But in fact, it arises because of the need to move border. And the need to move border in those cases, the Court of Appeal recognised may well be because of the disabled status of the individual. They had to move into that other area. So it's not as simple, I say, as saying, well, the statutory provision is what triggers the loss of the status. It's what triggers the operation of the statutory scheme.
If the family had been sufficiently well off to provide the care at home for their mother, she wouldn't have had to leave the home. She could have continued to have it as her only or principal home.
Yes, but obviously we're dealing with the facts of.
Well, but we've got to examine a wider range of circumstances, don't we, in order to test the proposition that this is a piece of legislation that breaches unjustifiably the Convention and the Human Rights Act.
Yes, but the point then, my lady, it sounds like that is being made is that so long as you were well off enough to stay at home, then in those circumstances you don't lose your rights because you can succeed because you've been able to make sure that your mother stays at home.
Well, I'm testing whether it's the condition in the legislation that is causing the difficulty, or whether it's a characteristic that amounts to status in relation to Mrs. Mailley. That's why I'm asking you
Yes,
the
but could
question.
that not also, I would suggest, be said in relation to any sort of disabled status case? So if, for example, say in relation to the status of people in the bedroom tax case, for example, whereby the status was related to the disability and the need for a second bedroom, well, if they were well off, they could have left and moved and gone somewhere else. They might have been able to buy the house off the local authority and built an extension. But we have to look at the circumstances in which the individuals live, their means, their conditions, those circumstances, and see whether it applies to a particular group, it might be, of people who would not be able to do anything but avoid leaving in particular social housing to go into a residential home.
The reason your client didn't inherit, or didn't succeed rather, was because there was no assignment.
At the time, her mother moved into.
Well, there was no assignment.
No, that's fine.
I mean,
But obviously, for the tenancy to be assigned to her, she has to meet the same conditions that one has to meet on a tenant's death, i.e., to reside there as your only principal home and for.
Well, you don't.
12
Well,
months.
does the comparative death come into it? She didn't. The property. There was never a question of her succeeding on death. because by that point, the tenancy had come to an end. The reason she didn't succeed was because it was never assigned.
Yes, but the point that I'm making in relation to that is that you can only have it assigned to you if, had she died at home, you'd had to meet the same criteria for an assignment to take place, i.e.
But if she died at home, you wouldn't have needed an assignment.
No, but you would still need to meet the statutory criteria.
Well, but
Which
there was
she
no
did.
question of
Yes,
that.
yes,
So
but in other
what my
cases-
lord is saying is that if she had assigned at any point before leaving the property, that would have avoided all of this. So
If
it's
she-
the fact of not having assigned before she left the property that is the reason
Well,
for
there are
not
very-
succeeding.
Well, indeed, but there are various reasons, one might say, in that why did she not assign? Before she lost capacity is one question, rather than necessarily before she left home, because as has already been pointed out, it's not all that clear as to when she lost capacity. But she certainly would have been able to continue to assign. It would have been available to her to assign if she'd had capacity up until the decision was made that there was no practical possibility of her returning home in October 2016.
Yeah.
But the admitted facts of this case are that she did not assign because, well, she was not capable of assigning at that time.
Well, at October 2016,
Yes.
but we're talking about a period before that.
Yes, but the crucial time in this case is the time in which her mother ceased to be able to occupy her only principal home.
Why is
Why-
that
is
crucial?
why
Why
is
is
that
that
the
crucial
crucial
time? Sorry, also the same thing at once. Not helpful to you, Mr. Stark.
Sorry.
We all happily we're saying the same thing, not three different
Well,
things.
it's
Which
crucial.
I
It's
find.
crucial it's crucial if one goes back.
Why is the timing matter?
It's crucial if one goes back to for two reasons. If one goes back to the death question, so to speak, if her mother had died when she'd been in respite care, she would have succeeded.
Yeah.
The second point is, if the mother has ceased to occupy her own principal home, and the tenancy has been brought to end by notice to quit, then there's nothing to assign.
I know you keep on taking it back to the death question. I'm not stopping you doing that, but I come back to the question here. What triggers the situation is your client. There was never an assignment.
Yes, but as I said, the reason I come back to the death question is because only if you're entitled to succeed on death can there be an assignment.
Only if you're entitled to succeed.
Yes, that's
on
right.
death
Yes,
can there
only
be
if you're
an
entitled to succeed. Because if I can take you to section 91C, which may be more helpful.
Okay. Well, so you can only assign to someone who's entitled to succeed on death.
Yes, if I can take you to the exact wording of the section.
Okay.
In fact, it may.
This is all in the new report file we got today, is it?
Yes, I think this section may be sufficiently set out in the original.
Okay.
Is it section 91?
90,
Section 91.
yeah,
Yeah, page
That's-
16 of tab
of
4.
the new one.
No, oh,
Thank you.
Yes, in section 91, as I've already said, points out that you can't assign except in these circumstances, and that if you assign, so there are three exceptions. Sorry, there are 91.3. The first two I mentioned. 91, an assignment to a person who would be qualified to succeed the tenant if the tenant died immediately before
Okay.
the assignment.
All right. Thank you.
But all that means it's a reference back to qualifications for succession,
Yeah.
which in this case are having
12
lived
months.
for the previous 12 months as your principal home with the tenant in the
Yes.
property.
Yes, but the point is, I don't want to stress it again, but the point is that you only have that right if the tenant had been at home and he had died immediately before the assignment.
Death isn't.
No, it's not actual death. This
It's
is
not actual
It's
death. It's a 12-month. It's
Yes, if
It's a
the
12
tenant had
it's
it's-
the
been-
12-month thing.
it could have
that is-
said. It could have said. Transpose the words from 80 whatever 87 into 91.3, couldn't it? It just means 12 months. Isn't it?
Well, there's two things. You must be occupying your own principal home and have resided with the tenant for 12 months before.
You don't have to die. Sorry, this sounds. I don't mean to put this to sound disrespectful. It's not necessary for the tenant to die to trigger this. So death. The question of death is, why is it relevant? I'm not expressing it very well, but I'm snapping my way towards the point. Forgive me, Mr. Stark.
It's because it's parasitic's the wrong word, but it takes you back to the death provision in section 87, because what this provision is in my submission saying is that there are two ways that a tenancy can, in those circumstances, make its way from a mother to a daughter. Just using those two members of the family as an explanation. One is on a first succession under section 87, where you have to show that you've occupied the premises as your only principal home, continue to do so as a member of the tenant's family for 12 months, at least 12 months before the tenant's death, so long as you're not a successor. So that includes those cases like Samawi and Gangera, which is a completely different situation, where Parliament has clearly said,
No.
We're drawing the line here. And it's that right that is then protected during the life of the tenant, potentially by section 91(3), i.e. you don't have to wait for the tenant to die.
Yeah.
But
Well, if you waited till the tenant died, you wouldn't be able to get an assignment.
no, but of course if the tenant died at home, you'd have succeeded.
Yeah,
But,
exactly.
but
So the question of death is irrelevant in a sense. The question is, do you get over the 12-month limit?
Yes,
limit.
but it's
That's
the,
what
que-
that means.
it's the question. But if maybe death is the wrong word to stress, succession is perhaps the most important. The question of succession clearly is not irrelevant, because you had to be entitled to succeed on death to receive an assignment of the tenancy to you from the tenant.
But that's a question that can't be answered until the tenant dies. It's got nothing to do with death. Other than that, section 91(3)(c) cross-refers to the condition in section 87, which applies when the tenant dies. So the question is simply, when you make the assignment, has the person been living as another member of the tenant's family throughout the period of 12 months ending with the date of the assignment?
Yes, which is what then the reference in 91(3) saying had the tenant died immediately before
Sorry, I was probably my
assignment.
fault, Mr. Sark. I'm probably not following the argument.
I mean, why is it? I mean, it is worded in that way, but it could just have transposed the words from 87 without reference to dying or death at all, couldn't it? Why did it do it that way? Who knows?
We don't know what they did.
Anyway,
But it may be appropriate if I
well,
move on
anyway,
to the outline
yes.
of the statutory scheme at that point.
Yes.
If I could perhaps turn to Article 14, and I'm aware, my Lord, that obviously there have been lots of cases about Article 14, and there are various principles that can be extracted from them. And rather than take us on a
Would you cover the well-covered ground?
yes,
in
rather than
which
take us on a tour of all these authorities, if I may say where I believe that we have now reached in relation to the application of Article 14, rather than going through all those.
Before you do, it's common ground, isn't it, that Article 8 is engaged?
Yes, it's within the ambit of Article.
So we're in a situation where Article 14 potentially applies.
Yes.
Yeah.
So we're into the stages
The
of
question.
status.
The SC question.
Relatively similar and justification.
Well, we're very familiar with this. See, it's raised a lot in this court.
So if I can take you through just perhaps one point, the point that arises from SC. Of course, the point that Lord Reid made in SC was to refer to the fact at paragraph 71 of the diminishing nature of the need to prove a status.
You want us to go to SC?
Yes, please. It's tab 37.
It's in the second volume. say paragraph 71.
Yes. Page 836. Might be helpful to read also in the context of Lord Reed's approval of what Lord Justice Leggett said at paragraph 69. So Lord Justice Leggett agreed with the charge. The words on any ground, such as to earn another status, were intended to add something to the crime of discrimination, because the status could not be defined solely by the difference in treatment complained of. It must be possible to identify a ground for the difference in treatment in terms of a characteristic, which was not merely a description of the difference in treatment itself. On the other hand, he observed that there seemed to be no reason to impose a requirement that the state should exist independently, in the sense of having social or legal importance for other purposes or in other contexts than the difference in treatment complained of. In that regard, Leggett L.J. referred to some illustrations in the court and domestic case law, such as the judgment of the European Court in Paulik and Slovakia, where there was no suggestion that the distinction relied upon had any relevance outside the applicant's complaint, but this did not prevent the court from finding a violation of Article 14. And it may, whether it's recalled, that was the case where Mr. Paulik couldn't disprove a court finding of paternity against him, even though we had a DNA test to show that he wasn't the father of the child in question, because there was no mechanism for that to be reviewed. That was counted as a status in those proceedings, even though it had no relevance to the rest of his life or to the rest of matters concerning him. And then if I can skip over the application for facts in the two-child case, he said, I respectfully agree with that reasoning, with that conclusion. I would add that the issue of status is one that rarely troubles the European Court. In the context of Article 14, status merely refers to the ground of the difference in treatment between one person and another. Since the Court adopts a stricter approach to some grounds of differential treatment than others when considering the issue of justification, as explained below, it refers specifically in its judgments to certain grounds such as sex, nationality and ethnic origin, which lead to its applying a strict standard of review. But in cases which are not concerned with so-called suspect grounds, it often makes no reference to status, but proceeds directly to a consideration of whether the persons in question are in relevantly similar situations and whether the difference in treatment is justified. As stated in Clifton, the United Kingdom, para 60, the general purpose of Article 14 is to ensure that where a state provides for rights falling within the ambit of the Convention, which go beyond the minimum guarantees set out therein, those supplementary rights are applied fairly and consistently to all those within its jurisdiction, unless a difference of treatment is objectively justified. Consistently with that purpose is added, while there may be circumstances in which it's not appropriate to categorise and impute difference of treatment as one made between groups of people, any exception to the protection offered by Article 14 should be narrowly construed. Accordingly, cases where the court has found the status requirement not to be satisfied are few and far between. And a further example of that shift is to be found in the victim of trafficking case, which follows on from it in the bundle. That's at tab 38A in the Criminal Injuries Compensation Authority.
This is Lord Lloyd Jones.
Yes.
Where do you want us to go in this? Is it tab somewhere around paragraph 67?
89957.
67?
57.
57.
Sorry, which paragraph?
Paragraph 57, page
57.
899.
899.
Thank you.
And this was a case when it may be recalled, victims of trafficking came from Lithuania were denied compensation because they had unspent convictions for theft and burglary in Lithuania. And they said, they put forward two possible statuses, but one status they said the status was as a victim of trafficking with unspent convictions. And what Lord Lloyd Jones said there was, the recent jurisprudence in Strasbourg and in the Supreme Court has shown a significant shift towards taking a broad view of status under Article 14. and as a result, the concept of other status must now be generously interpreted. In this context, it seems to be artificial to attempt any longer to distinguish between the gravity of an offence and the characteristics of an individual offender. In this regard, I find compelling the reasoning of Lady Black in Stott. No doubt what an offender has done has led to a particular sentence being imposed, which reflects the culpability of the offender's conduct, but once imposed, the sentence has significance independent of what the offender has done. This applies with equal force to a custodial sentence and to a community sentence, each of which has its own instance and consequences. In my view, having an unspent conviction is an identifiable personal characteristic.
You're going to read 58 and 59. I'm not asking you to read them aloud, but they...
Yes, I was going to come on to the independent existence condition. Okay. What is then said in relation to the independent existence condition, he sets out what it is, which is the point that I think Lord Reed was also making, namely that a status is the ground for the difference in treatment, not defined solely by the difference in treatment itself.
Yeah.
And he then says at paragraph 60, when the matter came before the European Court of Human Rights in Clifton in the United Kingdom, that court was dismissive of the point, stating in paragraph 60, further, the court has not persuaded that the government's argument that the treatment of which the applicant complains must exist independently of the other status, upon which it is based, finds any clear support in its case law. It then went on to explain in a passage cited at paragraph 42 above, the question whether there's difference of treatment based on a personal identifiable characteristic is a matter to be assessed taking into consideration all of the circumstances of the case and bearing in mind that the objective of the Convention is to guarantee practical and effective rights. The issue is nevertheless one of importance, and since Clifton in the United Kingdom has reappeared frequently in domestic cases. The language of Article 14 requires that discrimination should be on the basis of one of a number of identified grounds or other status. If it could be defined solely by the difference in treatment complained of, the words on any grounds such would add nothing to Article 14. And that's from Lord Bingham back in Lord Clift. And then he refers to the Doherty case, which is now the one that I think relied upon my learned friend in support of her additional reasons. It wasn't put to the judge below. The question arose for consideration in Doherty, Sean Doherty, legislation repealing the provisions of the Criminal Justice Act 2003, which provided for sentences of imprisonment for public protection, brought into effect on the 3rd of December 2012. However, the commencement order stated that the provision was of no effect in relation to the person arrested for that date. The appellant, who had pleaded guilty to 2 offences on the 13th of November 2012, was sentenced on the 20th of December to an indeterminate sentence of imprisonment for public protection. He appealed, amongst other things, on the grounds that the discrimination between a person convicted of identical offences was unlawful under Article 14, read with Article 5. He submitted that it was on the grounds of other status. As a prisoner who is subject to an indeterminate sentence. Lord Hughes said that assuming the status of prisoner subject to a particular regime could in some circumstances amount to sufficient status to bring Article 14 into question, it could not do so if the suggested status is defined entirely by the alleged discrimination. But I say that when one looks at what was meant in Doherty, it means this, is that Mr. Doherty said, my status is as prisoner subjected to an IPP, and I'm complaining about being a prisoner subjected to an IPP because I'm a prisoner subjected to an IPP. That's miles away, I would say, from cases where it's your personal or identifiable characteristic that has led to the difference in the treatment in how the statute treats you. There's no personal identifiable characteristic at all shown by him. The only thing he's saying is, I'm being discriminated against, in effect, because I'm being discriminated against because of what you have done to me in relation to this particular sentence. He has no alternative status other than defining himself entirely by the sentence to which he's been subjected. And that's why the courts have said, I say, and looking back to Cliff, the need to narrowly construe any exceptions to status. And when referring to the question as to being defined by the difference in treatment itself, solely defined by that difference in treatment. And of course, we would say that that cannot be said to be the case in this case, because Miss Mailley is defined by the 3 parts of her status, which are, firstly, her own part, which is as someone who would otherwise be a qualifying successor, and secondly, of a tenant, the sixth qualifying successor otherwise to a tenant who permanently had to cease to reside in their home because of ill health or disability. And thirdly, who at the time was incapable.
Sorry,
of
do you want
assigning
us to take a note of this? Because you're going very fast for my.
Yeah,
I don't.
so I
can
think,
can you go
yes.
back? Because this is important.
So the
You
three
say-
factors.
The three facts say that if I take you to my skeleton argument,
Sorry, I should have. It's just
It's in your skeleton, is it?
yes.
Yes.
It's paragraph 31, page 35.
Thank you very much.
It's in the context of the MOC case, which obviously I'll come on to. So I say that.
So that's what you're referring to.
So I say that deals with the property point. It's something very far away from a case such as this.
So I mean, two of those are the conditions of the legislation. B is the one that you say relates to individual characteristics. That's the reason why she ceased to occupy as her only or principal home was her disability, lack of capacity, whatever, however you want to describe it.
Well, I
But
would
the
say
others
B-
are
sorry.
conditions of the legislation, aren't they?
Sorry, my lady, I say B and C.
Sorry? You say B and C. Okay.
The effects of her ill health were such that she was incapable on that date of assigning the tenancy to her daughter.
Okay. So B and C are the personal qualities, but A is a condition of the legislation. All right.
And we say, obviously, that she can rely upon those factors of her mother because of the Kubarina and Croatia case.
I don't know that, but is that to do with associative discrimination?
It is. If I can
So
take you to
that's well established.
yes, but there is a paragraph in there which I think is also helpful to me in that regard in relation to someone's status. It's tab 29,
Sorry, tab.
29 in bundle 1,
Thank you.
page. Start with page 484, just the summary of the document. Page 7. And it's the final sentence which you maybe refer to the question of associative discrimination. The alleged discriminatory treatment of the appellant applicant on account of his child's disability, in the first person or legacy, and whom he provided care as a form of disability-based discrimination covered by Article 14.
Page 7.
And it's explored a bit later in the judgment and the question of application of principles to the present case, page 509.
Sorry, which page are you on now?
It's 509. I'll start with paragraph 75.
Yeah.
So, in the Guberina case, the court notes it was undisputed between the parties. The circumstances of the present case concerning matters of taxation fall within the scope of Article 1 of Protocol 1. Only Article 14 of the Convention applicable. The court sees no reason to hold otherwise. And that question was whether the disability of the applicant's child brought the applicant's situation within the term other status. And at paragraph 76, the court has already held that a person's health status, including disability and various health impairments, fall within the term other status in the text of Article 14 of the Convention. So it's a wider term, potentially, than disability itself. And of course
Health status.
health status, including disability and various other components, fall within the term.
Having said, I was grateful to the parties for preparation because I should make a small complaint. And the bundle is over over 500 pages in it. And somewhere in the rules, there's a rule which said no bundle should exceed 350. Just making that point. As you can see what's happened. And the bundle has
They're very
come out.
packed
And
as
having
well.
started at tab 3 and then gone to tab 29, it's been a bit of a struggle. But never mind. I've got your point.
And then at 76, 77, sorry, 77, the present case concerns a situation which an applicant did not allege discriminatory treatment related to his disability, but rather his alleged unfaithful treatment on the basis based on the disability of a child with whom he lives and whom he provides care. In the present words, in the other words, in the present case, the question arises to what extent the applicant suffers less favourable treatment on relation and grounds related to the disability of his child. So again, it's a very close personal relationship here. Again, the mother who she looked after and whom she provided care and who she lived with all this time, we say that the discrimination is associative. Now, it is right to say that the courts have perhaps also adopted a wider approach to status in some cases, one of which is Stevenson, actually found at tab 28, just in front of Guberino.
Are you just showing these as illustrations, or is there a proposition that you're advancing in relation to?
Well, no, it
These
could be said
cases.
that Stevenson is another illustration of the diminishing importance of status. It could be said equally in Stevenson that it went somewhat beyond that, because the only status she had in that case, a bit like a status in the Powledge case, was as an applicant for income support at a particular time. Had she made an application for income support in 2009, she'd have been able to get a bigger loan.
But it wasn't the fact of being an applicant for income support that gave rise to discrimination. It was one of the rules within the income support scheme that she was relying on. She didn't define herself by reference to her differential treatment. She defined herself as a benefit recipient. That was the status.
Yes, but
So
yes, a benefit recipient who was subjected to differential treatment.
Yeah.
Yes.
I'm not sure how it helps us.
Well, yes, I'm not aware. Obviously, there are lots of cases on this point. To the point that I was simply seeking to say that it's actually outside, one might say, the criminal sphere. The vast majority of these cases take this approach to status that's reflected in what Lord Reed said in SC.
To what extent do they buttress your characterisation of status in paragraph 29 of your document? Is it 29 or 39? 39. 29. You're 31, sorry, 31 on page 35. That's how you characterise a status. How do you say these authorities support this characterisation?
Because the test we say that for the court to apply is there an identifiable characteristic in these cases? And the identifiable characteristics we say upon which we are being treated differently are the combination of these three characteristics. That, but for those characteristics B and C, she would have been able to either have the tenancy assigned to her or to have succeeded if on the time of death. So the reason for the difference in treatment are the reasons, firstly, that led her mother to leave home, have to move into residential care, namely her mother's disabilities or her mother's ill health conditions, which is recognised very clearly as a status by Guberino as an example.
Yeah.
And secondly, by the second effect of her mother's conditions, which was the inability to assign the tenancy to her because of the dementia that she was suffering at the time that she ceased to occupy the premises of her only principal home. Those are clearly identifiable characteristics away from the difference in treatment itself. important thing is, I say, is to then turn to what the learned judge said in relation to this, which is his finding was that it couldn't amount to a status because of the involvement of the question of capacity in the assessment of a status. He didn't say that her other health conditions wouldn't amount to a status. It was the capacity issue that led him to find that this was the case. So if I can take you, obviously you've read the learned judge's.
Right, just give me a moment, Richard. I've asked my clerk to kind of bring my computer in because the bundles are just unmanageable. Thank you very much. Carry on, Mr. Stark. Thank you.
The learned judge dealt with the Article 14 argument in the case from paragraph 161 onwards of his judgment. 162, sorry, page 132. If I can take you to this issue, this arises at page 138.
Great. I can do the call back. Well, that's
Para 178, page 138 of the core bundle.
thank you. Yes.
And in MOC, there was an argument, and it's probably helpful to go through MOC in detail, because I think only by doing so, we say, can it be shown that it doesn't have the effect that the learned judge suggested it did. That's in.
Just before you do, if the respondent is right and there aren't any separately identifiable characteristics, what you're doing is relying on differential treatment as as in effect the status, then we don't need to get into capacity. Is that right?
Well, no. In my view, I don't
Wrong.
say, well, in relation to if the defendant is right that someone doesn't have a status at all, then the findings of the judge in relation to status aren't material, potentially. But if...
So we wouldn't need to trouble ourselves about the capacity issue on that basis. I'm not saying we've reached any conclusion about it. I'm just checking whether it still arises.
Well, if you find that someone doesn't have any status, that's
Any
the end of the
relevant
inquiry,
status.
isn't it?
Yes. Well, that was my thinking.
Yes, that is the end of the inquiry.
Yeah. Okay.
But obviously the point that I make is that there is absolutely, although the first point would be that there's no material at all,
Yeah.
showing that this is not anything other than based on an identifiable characteristic.
I understand that. And
And-
you say he was wrong about capacity.
Yes.
Okay, so I've now got MOC electronically. I hope my colleagues have got it in paper in the form which works.
MOC, the question of capacity arose in what might be said to be a rather contrived manner.
Sorry, Mr. Stark, can you
Yes.
remind me which tab?
Sorry, MOC is at tab 39.
Page 913. Those bundles. Having been critical of the paper bundles, I should point out that the electronic bundle numbering and the paper bundle numbering are the same. So the Master Rules would be happy
He would.
were he here, and so are we. Thank you very much. Au revoir. So so we've got the head note on 913. Where do you want us to go in the? You were saying it's rather contrived.
Yes, because this was a case, if you recall the Matheson case before, the very disabled child who lost his disability level allowance because he had to go into hospital.
Yeah.
And that was on the basis that the care component didn't need to be paid because he was in hospital.
Yes.
And the Supreme Court said that was not compatible with Article 14 because the evidence showed that in fact children in hospital for long term received a substantial amount of care from their parents and not just from the NHS. And in those circumstances, removing the care component was unlawful.
Yeah.
Now, MOC wasn't a child, he was an adult. I think in his late 50s. He'd been living for a time with his sister, who was also his deputy for the purposes of the court of protection. But he also, like the boy in the Matheson case, had to go into hospital. The hospitalisation rule provides for an adult that if you're in hospital for more than 28 days, you lose your disability living allowance
Yeah.
for the same reasons that
Yes.
you put forward in maths. And that's what happened to him. His capacity was completely irrelevant to that issue. He would have lost his disability living allowance whether he'd been entirely incapable of managing his own affairs, any affairs, or whether he'd, because of physical reasons, he'd had to go into
Are you coming round to saying what Lord Justice Singh said was obiter?
But, well,
Is that where you're going with this? And supported by Lord Justice Peter Jackson?
yes, because both of them say, I am coming around to that, but I want to go somewhere first before I get
You want to
if I
Sorry.
may.
Let me just carry on. Do it. Sorry, I shouldn't have. Just so I'm clear. Yep.
So the first point that one makes in relation to that, after a rather jumbled way that the case finally made its way to the Court of Appeal, was that the argument was being put, it seemed that he had a status, one turns to the judgment of Lord Justice Singh, either as paragraph 32 on page 922 before the upper tribunal, as an incapacitous, severely disabled adult in need of lengthy inpatient hospital treatment, or a severely disabled adult who lacks capacity to make decisions about care and medical treatment in need of lengthy inpatient treatment. So the point that we say about it being very much a peripheral issue was that, in fact, neither of those had any effect on whether the hospitalisation rule would otherwise apply to him. What was appeared to be being said in this case was that because of the fact he lacked capacity and he had a deputy, that it was discriminatory for the deputy not to continue to receive the elements of the disability living allowance and the care and the mobility components. The upper tribunal rejected that argument for a number of reasons. Can we set out at paragraph 36. Page 93. The position is different from that of a severely disabled child because the evidence shows differing patterns of care for adults and children. The position is different from a severely disabled person not in receipt of lengthy hospital inpatient treatment, as that person is not receiving publicly funded care by the NHS. The evidence failed to show that the consequences of MOC's lack of capacity made his situation different from a capacitous person in the same position, which is the point that I've just made. The limnos discrimination did not arise. And the judge observed that the lawfulness of the hospitalisation rule cannot be determined by what was being done in this individual case, irrespective of what is objectively required. And he also found that the appointee had not succeeded by this material in demonstrating expenditure that could not be contained within the means tested benefits remaining available to MOC, even allowing for the fact they diminish over time. The applicant's submissions after permission to appeal was granted was that there was an error in finding that a severely disabled adult in need of lengthy inpatient hospital treatment, who for the time being is being treated as unable to make decisions as to care or medical treatment, could not be a status for the purpose of Article 14. We can leave aside 2 or 3 because they abandoned those arguments before the Court of Appeal. And we've gone then to 44. Ms. Amanda Weston, who did not appear QC, did not appear below, submits that the 2 main issues arise, one relating to his status, and the second on the upper tribunal's conclusion on justification. Her fundamental submission is the judge erred on the status issue, and that this fundamental error then tainted his approach to the issue of justification. Ms. Weston submits that any approach to a capacity-based status must recognise the prejudice in the real world of a disabled person whose autonomy is so fundamentally compromised that a deputy has been appointed. The deputy must promote and protect his autonomy and identity, in particular by communicating with those delivering personal care and services at hospital. And then, having made further references to the nature of the lack of capacity, she said that the hospitalisation rule disadvantages MOC because the suspension of the care component has an adverse effect on his deputy's ability to fulfil her function on his behalf in relation to his care and treatment. The reason I say, therefore, this is a rather contrived argument is it was for the purpose of the deputy retaining the disability living allowance payments. But there was no material at all before either the upper tribunal, it seems, or the Court of Appeal that showed that the deputy needed that money to be able to carry out her duties, or that as the consequence of being a deputy there are any particular caring requirements that you have as a deputy. Many deputies may well have up to no caring requirements or involvement with an individual.
Why did that matter for the purpose of the argument?
I'm sorry,
Why did that matter for the purpose of the argument? I mean, you say, I'm not quite clear what contrived.
well, it may be said that the justification, perhaps, for the proposed difference in status was something that appeared to be contrived. There was no evidence in support of it. But the second point that I'm making in relation to that question, as I said, is that when one looks at the bottom line as to the application of the hospitalisation rule, his capacity was irrelevant to it. Whether or not he had capacity or not had no effect on whether or not the hospitalisation rule applied to him.
Right.
If we can turn then to what the court said about the question of capacity, I think one looks at one has to look at the contents of what was being argued by Miss Weston.
And what are you going to say about this? Do you accept that we're bound by what
No,
Lord
I don't.
Justice Singh says, or do you say it can be? What's your proposition?
My first proposition
Yeah.
in relation to this is that it's right that it is not strictly binding. The remarks obit it because
Right.
both Lord Justice Singh and Lord Justice Peter Jackson found in this case that the justification wasn't made out. They both were not. They both said in relation to what they said about capacity. If I can take you to Lord Justice Singh.
They say they'll assume it without deciding.
Yes.
Yes. So you're saying what's been said about capacity in that case is not binding.
Yes, it's obit.
And you're going to invite us not to follow it. So,
My Lord, if I can,
we mustn't just. Mailley and I just want to.
We just want to know where we're
want
going.
to see the direction of travel.
yes, I am.
But is
It
yes?
may be
Is
easier
that
for
a
me to-
yes? I think
Yes,
it
well, if
must
I can, the direction of travel may be easier to
Okay.
ascertain if I can just move on in
All right.
relation to.
Forgive us for interrupting you.
Yes.
Carry on, Mr. Stark.
So the first point I would say is that the reference to capacity has to be considered in its context. What neither Lord Justice Singh or Lord Justice Peter Jackson were saying were saying that capacity itself can never be a status. What they were being asked to look at the capacity. So that's the first point. The second point is they were being asked to look at capacity in the context not of one issue-specific decision, but as someone who was being treated as unable to make decisions as to, for the time being, is being treated as unable to make decisions as to care or medical treatment. So that could apply to a whole panoply of decisions that needed to be taken in relation to this individual. For the time being,
Where did you get that specific?
that's the argument as put by Miss Weston,
This Western in the paragraph you just read. Is that right?
paragraph 40,
Okay.
42, sorry.
Thank you. Where's that particular phrase you use? I can't see it. My fault.
It's under ground 1. Upper Tribunal Judge Ward erred in finding that a severely disabled adult in need of lengthy inpatient hospital treatment, who for the time being is being treated as unable to make decisions as to care or medical treatment, could not be a status. That is where we say the criticisms made by Lord Justice Singh and Lord Justice Peter Jackson have weight, because of the potential of there being all manner of decisions, but potentially that someone might move in and out of capacity over a period of time over which those decisions have to be made. And indeed, that definition, that type of definition of capacity, is not issue specific. The reference that Lord Justice Singh makes, when it turns to paragraph 64 of his judgment, he says, the first issue is whether there's a relevant status. I was at one time attracted during the hearing to a possibility that relevant status is a severely disabled person who needs hospital treatment and has a deputy appointed by the Court of Protection.
64, is it?
64, page 299. Miss Weston said was not prepared to accept that was a relevant status. Well, that's perhaps not surprising because you wouldn't have won on that status at all, because the mere fact of a deputy would not have been made any difference. Paragraph 65, it says, I've reached the conclusion. The judge cannot be criticised for reaching the conclusion which he did on the question of status. He was right to observe the question of capacity such as not a status. First, the scheme was designed to move away from a status-based approach to a functional approach. In other words, to focus on particular decisions at a particular time. Secondly, there needs to be reasonable certainty. A person's capacity may change from time to time and may do so quickly. That's not a sound foundation for the status required by Article 14. Certainly not for the status put forward in this case. And this is the point that I was made in relation to why I said perhaps it was contrived. I can see no logical connection between the purpose of DLA and the role of a deputy appointed under the 2005 Act. There were times in the hearing when it appeared to be suggested what this case is really about is whether a deputy is entitled to claim expenses performing her tasks as a deputy. Whether or not that would be a good idea as a matter of social or economic policy has nothing to do with whether the rule under challenge is discriminatory. And then the point that my lord has already pointed out, I would be prepared to assume without deciding that he had a relevant status, was that the judge did as well. I do not accept that his approach went on to taint his position in relation to justification.
Why you say going back to, is it relevant to your case that you say that Miss Weston's characterisation of capacity was not issue specific? Because at the moment I'm not sure I agree with that proposition.
Yes. I do
where is
say.
it 40,
Sorry.
what was it, 42, wasn't it?
Yeah, 42. 42.
I mean, in the Court of Protection, the question of whether someone has capacity to make decisions about care or treatment is issue specific. The question of how specific you have to be issue specific.
Yes, but
I mean, that is an example of an issue specific capacity.
But your point, well, I don't know, Mr. Sark, maybe that this is a different, our case is a different case on the facts, because there is no question but that the defendant's mother eventually completely and utterly and irretrievably lost capacity for all purposes.
well, indeed, she did do so.
So it's not a question of, moving in and out of capacity or this decision or that decision. The whole thing just went.
Yes,
Well, for you, the question is capacity to assign.
yes, which is the issue specific question.
It may be your point is not so much that what Lord Justice Singh and Lord Justice Peter Jackson said was obiter, but that it's distinguishable.
Well, it may be obiter and distinguishable.
Technically, all right.
Perhaps it's right to say that I place more weight on it being distinguishable
Yeah,
than I do on it being
mean,
obiter.
yeah. This wasn't, in fact, your case firmly, whatever would be the case, whether or not it's right, what was said about fluctuating capacity in MOC, the present case is not a case of fluctuating capacity. Okay? Yeah.
But if I may then take support in relation to that, from the decision handed down this morning, which we are very grateful to the composition of the court in Vanshaw, I think is how it's pronounced.
I have been told how it's pronounced permanently, but I've forgotten to say how you pronounce it.
I said Vanshaw.
Evangelist.
Ivanchuk.
Mr. Royston tells
You
me.
did tell me that. Ivanchuk, thank you very much. So we've got...
Has it now been handed down? Yes.
Okay. In the copy that we sent to you. The verse, presumably there's no.
The copy that obviously I've been working from, the one we were kindly sent by the.
Well, let's hope we're all working on the same. Is it on? Is it on?
Is it on Bailey?
Bailey? It's on Bailey yet.
I doubt it's on Mailley, but it's been handed down to the parties. I can circulate that.
You
to
have
your
got
clerk.
Can you?
Yeah, because we've got a double-spaced copy here.
Yeah.
So.
I've just in the last couple of minutes I've sent it to council,
Ah,
and I'll
Can you
send
forward
it
it to
down.
Miss Whit?
Can you?
Can you forward it to? Can you forward it to Miss Whitby, my clerk, and ask her to forward it to the 3 judges in court? Have you got your? You haven't got your there.
Sorry, it's all right. I've got a copy of
Well,
the judgment.
actually, maybe that's
in
not
about
the case,
it.
but-
I mean, it's a
Should we work?
copy-
Should we work off what we've got in the hope that we're dealing with the actual version? You'll know if there's been no change, has there?
Actually, I've got a copy of the draft. I don't think it matters. I think there
Was no material change.
no, there won't be any material changes
No.
between the draft and the down version.
And if there is, the one the lady ought to know.
Yes.
Okay, all right. Let's go. Let's not bother with any more copies. Go with what we've got. Okay, Mr. Stark.
If I can then turn to the judge's objections to the question of capacity,
You mean
Are we
Mr.
looking
Lord
at?
Mr. Justice Cotter?
Mr. Justice Cotter's
Right.
objection.
On the judgment. Yeah.
He starts at paragraphs 1812. And in fact, he's underlining at paragraph 181, which is page 139 of the core bundle.
Yeah.
For the purpose of this act, a person lacks capacity in relation to a matter if, at the material time, he's unable to make a decision for himself in relation to the matter because of an impairment of or disturbance in the functioning of the mind and brain, which reflects the point, the issue-specific point that doesn't simply say do you lack capacity or not. For, you might lack capacity for some matters and not for others.
And you say that was in October 2016
Yes,
as a matter of agreed facts.
yes. Then says at paragraph 183, presuming status can be identifiable solely through the circumstances of others, so that's the Guberina point, i.e. the circumstances of the mother, a characteristic is still required which must be something more than being merely identified with discrimination. As held in MOC, an individual's own capacity is not a sufficient status for the purposes of Article 14. Status requires a characteristic which has the quality of reasonable certainty. So certainty is his first point of objection. A 40-year-old, when considering discrimination which concerns an ability to make a permanent change, i.e. assign a tenancy, the main determinant of impaired capacity is cognition, and any condition affecting cognition can affect capacity. For example, capacity can be impaired in head injury, psychiatric disease, delirium, depression, and dementia. All can have varying impact on the condition of the mind or brain, and mental capacity can change over the short and long term. I cannot accept Mr. Stark's submission as it would mean that status for status, I assume that's contended for, there's a missing word,
Yeah.
can rest on shifting sands, whereas death is a certainty both in terms of inevitability and timing, when it occurred. Capacity may be lost and gained, and the material time may be down to a chance occurrence, e.g. a temporary deterioration in symptoms, or manipulated, for example, by a relative who wished to delay the assessment until they lived in the property with the tenant for a qualifying period of 12 months. Mr. Stark argued that there need not be uncertainty as the assessment of capacity could be at an identifiable point in time, the point at which a permanently ceased to reside at the property. However, this ignores the ability to regain capacity, and in any event begs a question and introduces yet further uncertainty. It's no way an answer to say this issue could be determined ex post facto. I won't deal with 185 at the moment. I'll come back to that. And then he says, finally, 186. In my judgment, the identification of the incapacity of a third party cannot be insufficiently certain to provide status for an Article 4. Can't be sufficiently certain, to provide status for an Article 14 claim.
Mm-hmm.
My Lord, I take issue with that in the skeleton argument on a number of grounds, for a number of reasons. At ground 1A, The first point is the one we've already gone through. It's the lack of a specific issue to be determined in the MOC case, i.e. that in that case consideration was being given to a much wider definition of capacity, rather than the question that one has to focus on, we say in this case, namely the capacity to assign the tenancy, the specific issue at the material time. Secondly, it's only one element of the three-part status that I have put forward. Admittedly, all those elements are important to the status, but it's not.
I know. Sorry to come back to this. Goes back to your the point you make about Ms. Weston's submission of the other MOC. But the question you have to ask yourself when deciding capacity is, what is the decision that has to be taken? And that decision can be a broadly expressed decision, such as care and treatment, or it can be a very specific decision, such as assignment. Both are issue specific.
But the difference in relation to the care and treatment decisions is they're decisions that are clearly being looked at over a period of time. It's not being simply said, was there capacity to decide whether or not he should have this particular treatment today on a particular time? Or to
Well, you check, as you illustrated from the citation from the statute, the judge cited paragraph 181, you have to look at a material time.
Yes, one does have to look at it in material time, but that's not how I say the status was being put. We were saying for the time being
here or in
MOC.
Okay, right.
We're saying for the time being, he didn't have capacity to account for all these issues in relation to decisions. What's one decision? Decisions in relation to care and treatment. So it was a wider number of issues that potentially could be said to be covered by that, rather than one specific issue, as we say, which was a specific issue relating to whether or not she could assign her tenancy at a particular time. Secondly, the point also that it was clearly not being said that capacity could not be ever a part of a status. So if, for example, unlike what had actually happened in the case, if the hospitalisation rule had said, if you go into hospital and you lack capacity to make decisions, you lose your DLA, but if you don't, you keep it, it would clearly be a status. And the point in the statute about being required to ask the question at the material time, we say the material time here is when she had to cease to occupy as her only principal time home because of her illness. Had she had capacity to assign at that time, she could have assigned it to her daughter, but because she didn't, she was not capable of doing. Because she was not capable of assigning it, she didn't, and that was the consequence of it.
She didn't.
She didn't.
You don't know, because she might have chosen when she had capacity. She might have made a rational decision not to assign it. Well, we simply don't know.
Well, my lady, the judge very much found on the facts that he thought it extremely unlikely that she would not have wanted her daughter to succeed to the tenancy.
Well, perhaps we'll come back to this when we get to comparator. I'm not hurrying you along, I hope, unfairly, but I'm a bit concerned we're still in the weeds of capacity and we've got quite a lot to cover. It's probably our fault, or my fault, for interrupting you. So just keep an eye on the clock, would you, Mr. Stark?
Yes, but it's the point I'm saying is that the statute supports the point that it's you look at the specific issue. Did she have capacity at what we say is the relevant time? Having explained what we say that the elements of the status are. So that's the first point that I make. But I say that we're also supported in that in relation to the questions of certainty by what the Court of Appeal has just said in the Schwanschuk case. In that case, one of the arguments put forward by the Secretary of State was that the proposed status for the late Mrs. Ivanchuk was too vague. It was said by the Secretary of State it was far too difficult necessarily to work out whether she would have been entitled to bereavement support payment. I'm going to take you to I'm now looking at the draft. I don't know the page number is the same. It's paragraph 52.
I think go just go with paragraph numbers because that's someone was looking at electronically. And someone 52. Ground 2 status.
Yes.
So for the record, this is Lord Justice Underhill, with whom
Yes,
Mailley and Lord Justice Falk agreed. Yep.
and he firstly referred to the observations of Lord Justice Henderson about the question of the utility of the concept of status at all. In paragraph 56, there's reference to the ability to rely upon the status of a third party. What was said at paragraph 56 after what Mr. Sheldon said that it's too uncertain at paragraph 55 to constitute a valid status. He referred to the statement in Clift that it does not prohibit all differences in treatment, only those differences based on an identifiable objective or personal characteristic or status, for which persons or groups of persons are distinguishable from one another. He submitted that a status formulated by reference to an ability to work did not just satisfy those requirements, and in particular the requirement of objectivity. Inability to work was not an objectively determinable characteristic. Determining it would typically require an assessment of the degree of difficulty in working encountered by a disabled person, for which there were no absolute criteria. The objection had apparently not been raised by DFC and O'Donnell, and it is not addressed in the court's judgment. I do not accept Mr. Sheldon's submission. It is true that the concept of inability to work will often involve a judgment on matters of degree. The status as advanced is clearly not intended to be confined to cases where claimants are incapable of any purposeful activity. For example, if they're in a coma. The real question is whether the disabilities in question are such that throughout the relevant period they could not reasonably be expected to work, or to be precise to do paid work, such as they pay the minimum prescribed minimum level of NICs. Many characteristics which are well recognised as potential grounds of discrimination under Article 14 are not absolute in character and can typically only be identified by an evaluative exercise. One example is disability, recognised as another status in Gibraltar and Croatia. There are degrees of disability, and it may be necessary in a particular case to carry out an evaluative exercise in order to establish whether a claimant was indeed disabled in the sense relevant to that claim. Another example is what Ms. Callaghan referred to as the status of cohabitation, recognised by the Supreme Court in Re McLaughlin. And in a particular case, it may well be necessary to make a judgment whether the relationship in question was sufficiently close to amount to a cohabitation. In my view, an evaluative exercise of the necessary kind can properly be described as objective as long as it consists of a rational valuation of objectively established facts. There is nothing in Clift that contradicts that approach, which seems to be plainly consonant with the overall purpose of Article 14. The issue about status in Clift had nothing to do with objective determinability, and the statement quoted by Mr. Sheldon was really prefatory to a different point.
Yes.
Well, the point that I make is the same, that so far as the elements that we say amount to her status, namely those elements in relation to her mother, they are matters are clearly capable of being subjected to an evaluative exercise of the necessary kind if it consists of a rational evaluation of objectively established facts. So that takes me on to the following point, which is look at the questions that I raised earlier. Look at the questions that the court or an individual, or a local authority in particular, will be asked if we are right in relation to status. Firstly, would Ms. Mailley have been entitled to succeed at that time, had her mother not been removed into care, had been able to assign or had assigned the tenancy to? Secondly, the Tickner and Hearn question. The local authority has to answer in every case that it was to say, in relation to someone who enters into a care home? I.e., is there a practical possibility of them returning home within a reasonable time? The third question is then the evaluation of that particular issue-specific decision. Did the tenant have capacity to assign the tenancy to the member of the family at that time? Those are all questions local authorities are required often to ask themselves already.
Okay, well, we maybe get round in circles, but can we just go back to the first question? Having looked at the authorities, would the defendant have been entitled to succeed? That's how you put it.
Yes. Does she meet the what would be the
The
characterisation?
answer to that is no, isn't it? Because it's not been assigned to her.
No, the point that I'm making is, does she meet the criteria of being a qualifying successor but for the difference in treatment? Yes, she
Okay.
does, because she's
So
been
this
living
is
with
how
her
you,
mother.
in fact, what yours is not would she be entitled to, but does she meet the criteria? So that
Which are, firstly, that
yes,
she's
yes.
living
Does she meet the
principal
criteria for
home.
what?
Firstly, that she's living at the premises of her own principal home.
Sorry, does she meet the criteria for what?
As a
Forgive me.
qualifying
under Section
successor.
87.
And the qualifying successor
The qualifying success and criteria under Section 87.
in the event of death.
Yes.
Okay.
And that's just living there as her only principal home.
Yes, and residing with her mother through that period, and because her mother
12
would still
months
be,
preceding the
yes,
death.
and her mother would be treating and still residing there until she had to permanently stay. So I say that is the answer to concerns about certainty, is to look at it through the prism that Lord Justice Underhill examines it under Ivan Shuk. And if you apply that prism to those three factors, there are three factors that local authorities can easily, are used to answering, and are questions that have commonly been answered. The final question, obviously, as I say, the question as to whether or not someone has capacity to assign a tenancy is one the courts have been considering for hundreds of years, as at the time of the will or the assignment or transfer.
This is a local authority dealing with housing, not a court dealing with questions of capacity.
No, but the local authority dealing with housing
Yeah.
has to take steps in relation to how it regards the particular status of someone's particular statuses. So we'll look at each of those three elements, perhaps my lady. The first one is if, in the normal circumstance of a case, if someone dies and there's a member of the family, the local authority will always ask, are they occupying as their only principal home, and can you prove that you've been living there for 12 months? So they'll often ask for, proof of doctors and children going to the school in the end, those sorts of matters, proof of residence. So they're very used to answering that question, asking and answering that question. The second question, Tickner and Hearn question, they answered it in this case, they're very used to answering that question as well. The third question, in relation to whether or not someone has capacity to assign, is a question they would equally have to ask themselves if someone turned up with an assignment.
Would they?
If, for example, as someone said, I've had this assigned to me by my grandmother, just produces the document, local authorities won't necessarily take that at face value.
Is that right?
Yes, they will certainly want to have confirmation that the individual potentially signed it.
Isn't capacity assumed? I
Well,
thought
capacity-
that's the whole point of the Mental Health Act.
Capacity,
Capacity.
but
Sorry?
there are a number of
Mental
issues.
Capacity Act, I'm so sorry.
Yes, mental capacity.
Yes.
Yes.
Why do they have to explore it rather than
Because
assume?
local authorities may well wish to investigate, for example, whether someone's been subjected to manipulation.
Well, there'd have to be some evidential foundation. They can't just start investigating it. And they're not going to investigate it in the broad run of cases, are they?
Well-
Because they're going to assume it.
No, my lady, I would not agree with that. Local authorities, if someone...
What's the basis for this submission? What's the evidential basis?
My lady, well, if one looks at how a local authority would deal with an assignment, I would say the likelihood of how they would deal with an assignment. If someone turns up at the local authority offices with a deed of assignment,
Yeah.
and says this has been assigned to me, and now transfer the tenancy right into my name, please, without making any inquiries of the.
You're saying a local authority doing its job properly would have to inquire.
Yes, they would have to inquire.
And you're not saying there's evidence.
No, but it's something
I
that
would say,
they would have to.
yeah, okay.
They would find themselves potentially in a very sticky wicket if they just accepted that, gave someone the keys, declared them to be the tenant, and then it turns out the document may be forged. It turns out the document may have been obtained by misleading someone. But they are not going to just take that at face value, regardless of the question of capacity. And that's the point that I'm.
That's a different point. They might not take it at face value, but whether they'd have to investigate the capacity of the
Well,
individual.
again, that would depend on the nature of the investigations, my lady, that saying that they would make. They would almost certainly make inquiries of the tenant to confirm that's the case.
Yeah.
And that may well then disclose, for example, that there are issues about that tenant's capacity. That's the point that I'm making. So it's not as if it's not an inquiry if any assignment was presented to them that they wouldn't make. And of course, again, in relation to the linking, I would say, of the two factors, certainly when dementia is one of the causes of going into a care home, is this local authority knew that she had gone into this care home. They knew the reason she'd gone into this care home. And in those circumstances, they had made that admission in relation to the notice to admit facts that she had ceased to occupy on the basis of, and she was not in a position to assign the tenancy as of the 16th of October 2016 because she had advanced dementia. So the point that I make is that those are not difficult questions for a local authority to answer. And they're questions that local authorities answer and ask themselves all the time. And as I say, Evanship shows us they are questions that are capable of rational evaluation on objectively established facts. I turn then to ground 1B. This is the ground to which my learned friend objects, i.e. the proposed reformulation of status if as a potential response to the learned judge's concerns in relation to capacity alone. And if you recall in Evanship, there was discussion in relation to what Mr. Sheldon described as something called disability plus. The status that was put at paragraph 53, page 19, deceased was unable to comply with section 31(1), i.e. make any contributions, throughout her working life due to disability. It's convenient to refer to this status simply as inability to work, though strictly speaking, it relates to inability to undertake paid work to the extent necessary to generate payment of class 1 or 2 contributions. Mr. Sheldon referred to the status so formulated as disability plus, to note the fact the actual ground of the differential treatment was of Susie not having paid contributions, albeit that was as a result of her disability. Ms. Callaghan put the same point another way by saying that the status on which the claimant relied was a subset of her broader status of disability. But she said that situations of this kind were not unusual, referring to such cases as Matheson and Secretary of State for Work and Pensions. And the label disability plus added nothing useful to the analysis, and I agree. What I say is that in relation to the incapacity of the late Mrs. Mailley, that is simply part of it's a broad subset of all the other consequences of her disabilities. So what she is was being relied upon, obviously, in the Evanship case, was her inability to work, being a consequence of her inability to assign, and her inability to stay, are equally broad subsets of the disabilities that Dorothy Mailley had. So we're not changing or making a substantial difference in relation to the status. We're making the same allegations in relation to the consequences, but simply putting a different label.
Inability to stay was one, was it?
Well, the first one is obviously her inability to assign.
Yes.
The second one is the fact that as a result of her disabilities, she had to leave and was no longer able to stay in her home and had to move into residential care. They are both subsets of her disabilities. Just as not being able to work as a status was a subset
So
of
you're
the general
expanding
status.
the status question beyond capacities to assign to incorporate the reason why she's no longer in the property.
Yes, well, my point is that those three elements are all part of that, are all part of the status. Both her not being able to continue to live,
Right.
that's an identifiable characteristic arising from a disability, as is the inability to assign the property. The effect potentially of the refinement might be, say, well, if the learned judge is right about his concerns about individuals whose incapacity issues, although they arise from obviously from an impairment under Section 1 of the Mental Capacity Act, aren't necessarily disabilities, is not an exercise that I say it can be met by this point, that we are dealing with issues with individuals who it is a consequence of their disability that they're incapable of assigning or have to move in their home. We say that that's what we're doing, no more than that, in refining the question. And in that regard, I draw attention to the fact that in a number of the cases, the court has itself sought to refine the question of status as the matter has been argued. Indeed, in Matheson, the Supreme Court gave two different statuses. Both Lord Clark and Lord Reed agreed with both statuses. They agreed with the status that he was a severely disabled child in need of hospital treatment, and they also agreed with the status that he was a child in hospital receiving NHS care, which didn't relate to his severely disabled. So I said it is what I think is perhaps an arid exercise for the respondent to say that we're seeking to putting in a completely new argument. But if it were, we say this is a pure point of law arising from the facts established below. And it's not in dispute at all by anyone that she left home because of her disabilities, her arthritis and her dementia, and that she could not assign because of her dementia. And it's long established, as the Guberina case said, that someone's health status, and whether that's a disability or other elements of a health status, can amount to a status. I've already addressed the point in relation to uncertainty and the questions that the local authority would have to ask itself. There was one point that the learned judge seemed to be concerned about, which was the risk of undue influence or manipulation. But the point that I make is that is equally applies to someone who appears to have signed. There appears to have been an assignment. His point, he made one point indeed, about someone not letting a member of the family go into a home because the member of the family wanted to establish their 12-month residence. But of course, that could apply in any circumstances to whether or not someone who had no issues of capacity at all. It's not causative in that sense. If, for example, the tenant was suffering badly from arthritis, it was felt that she couldn't really manage at home, but had capacity in those circumstances, the learned judge's concern about someone being manipulated because they don't have capacity could equally apply to someone who did have capacity, who is manipulated because of family ties, relationship, some unpleasant form of coercive control. We don't know. But the point is that it certainly doesn't arise from her lack of capacity that someone might stop her going into a care home just so he can build up the 12 months residence. Indeed, it might be said it would be more likely to happen when someone did have capacity on the basis that they were holding them back for 12 months, so they then did assign the tenancy to. And I think Justice Laing has made the point about we're not concerned in this case with fluctuating capacity or someone regaining capacity. The learned judge appeared to be concerned about the potential situation where someone has been found to lack capacity, they move permanently into a care home, and then regain capacity. But the point is, of course, that doesn't have any effect on, it's very unlikely to have any effect on them, because the Tickner and Hearn test has to be satisfied as well. So they would still retain their secure status if that high test had not been met. So there'd be no question of a tenancy passing to someone who would then be able to regain it, because they've lost their secure status permanently because of the Tickner and Hearn test. And if Tickner and Hearn test wasn't met, this would not apply anyway. There would be no deemed succession, as we might label it. If I just turn that off. If I can turn then to grounds 2 and 3. Question that the learned judge found that this was not an analogous situation. In my submission, he was wrong to do so for 2 reasons. One, he applied the wrong test, or a wrong test. The second one is he didn't apply the right test. It's pages 187, paragraphs 187 and 8 at page 141.
Apply the wrong test and not the right test.
Oh, yes, I suppose it's the same thing.
I look forward to you develop those 2 points.
Well, the test that he applied
Was the wrong one.
was the wrong test, and then he didn't apply the right test. Maybe that's the better way I can.
A, B would follow from A, but I may be being too simplistic here, but let's see where we go.
Yes, he said in relation to an analogy, the comparative.
Which paragraph?
Page 187 and 8, page
Thank you.
141.
Got it? Yeah.
The third question is whether it's analogous, or of course relatively similar, relevantly similar is the other way it's been described. In my judgment, the Article 14 argument not failed on the question of status, it failed on this question. The 2 comparators were A, the potential successor of a tenant who dies at home, and B, the potential successor of a tenant who is permanently removed from a home as a result of ill health and is capable of assigning her tenancy, i.e. retains capacity. In my judgment, these situations are not analogous, as I've set out, if, as Mr. Starks admits, family members should succeed on the date that tenancy is to occupy the dwelling house as their only principal home, for reason not being able to continue residing there, by reason of their ill health and also being incapable of assigning their tenancy, the original tenant would lose their rights, even if they subsequently regained capacity. This could therefore be in direct conflict with their family members. This could not happen if the tenant died or voluntarily and with capacity assigned the tenancy. A right to succeed on a certain and permanent occurrence is not analogous to a right to succeed on an uncertain and potentially, possibly temporary basis. Well, I say that's wrong, and if we can, whichever way one looks at, which prism one looks through it first, because when one is considering whether or not situations are analogous, one looks at primarily at the aims of the measure in question. So, for example,
Don't you
Lord Reed
compare the position of those with the protected status or ground and those without it? That's what you're not looking at the aims of the measure when you're looking at what's an analogous situation.
Well, if one can turn to what Lord Reed said in SC.
Just remind us which tab.
It's in bundle 2. It's at tab 37, paragraph 59.
Could you possibly give me the page number in the bundle? Roughly. Give me a rough idea where we are, then I can find it.
So we'll look at it. So on page 834.
832.
Thank you. 59.
Yes, page 834. Difference is only relevant for the purpose of assessing whether there's been discrimination.
Do you?
Claimant is comparing himself with others in a relevantly similar situation. An assessment of whether situations are relevantly similar generally depends on whether there's a material difference between them as regard the aims of the measure. His analogy was not to look at the aims of the measure, but to look at his concerns about the consequences of dealing with the matters differently. That's not the test in deciding whether or not one is in a relevantly similar
Let's
situation.
follow this through. What are the aims of the measure? What is the measure in question in this case?
The aims of the measure is
What's the measuring, first
the
of all?
measure is the succession regime set out by the Housing Act 1985,
Right.
the succession and assignment regime.
So sections 87 and section
Yeah.
91.
Section 91.
So, yeah, yes. It's both. It's 87 and 91. Okay?
Yeah.
And what are the aims of those
So
measures?
the aims of the measure are,
You say.
so long as someone occupies as their own principal home, so long as they're a member
That's not the aim, so long as. That's
It
the
may well-
condition. Well, what?
my lady, if I can,
Yeah,
that's the
finished,
condition
actually.
It's a
on which I say
complicated
the aim is
Yeah,
based.
It's a very complicated aim.
Yeah.
Isn't the aim to limit succession rights, to preserve the pool of housing for the local authorities' needs?
Well, that's one aim, but it's not the only aim.
Right.
Okay.
Why don't
go
you
on.
characterise how you put the aims?
The
and then
aims
put-
of the measure
Yeah.
are,
All right, we'll write it down.
one can say,
Yeah.
I accept that it's because of the fact that it is limited to certain classes of persons. But the aims of the measure is also to ensure that members of the tenant's family who occupy the premises of their own principal home and have resided with the tenant for 12 months before either their death or the date of the assignment. We would say, in substance, the date when they are required potentially to leave their home, though I accept that an assignment could take place equally in a situation where the tenant remains.
Forgive me, Mr. Stark. There's quite a lot of qualifications here. It would help me if you could just summarise the aims of the measure in a straightforward way, and then add the footnotes, as it were, afterwards.
The aims of the measure then are that members of the tenant's family
Yeah.
who occupies their own principal home
Yes.
and have resided
Valid
with the
12
tenant
months,
for 12
yes.
months retain their home and succeed to the tenancy. That's my lady's right in that some of the aims of those measures, because of the way that the matter is set out, is to exclude people. So successors, if there's already been a succession, you can't succeed twice.
Yeah.
That's not to take any
Or
steps.
there
against
cannot
someone.
be two successive successions.
Yes.
Yeah.
Why isn't the aim to balance a recognition that some people should be entitled to succeed to a tenancy with a recognition that local housing authority will also need to allocate houses in most circumstances to new people who need them?
Well, that's a justification question, is it not, my lady, in relation to why is it said that it's justified to treat someone in this position differently?
Well, no, my question's a different question. My question is, why aren't those both aims of the statutory scheme?
But the aims of the statutory scheme, I say, are not to exclude people who would otherwise be entitled to succeed simply because of their mother's status. In this case, that relates to disability, i.e. because of the fact that the mother had to leave the home.
Where's the
and was not
tenancy
capable of signing it.
condition feature in all of this? Because that's something that you haven't really dealt with in your arguments. It's a feature to which the local housing authority does draw our attention.
Well, the local housing authority, I'm sorry, I didn't quite catch what you said.
Where does the tenancy condition in section 79 feature in all of this? Because on one view, there is no tenancy once the tenant ceases to occupy as only or principal home. See section 79.
Well, I think it's section 81, I think,
91.
that you're referring to.
91.
Yeah, sorry, but I got the wrong number, but you know what
91.
I'm talking
Yes.
about.
Yes, but the point in relation to section 81, section 81 only operates in this case because of the consequences of the status. That's the reason potentially for the difference in treatment, is because she cannot remain in the premises because
Is
of her
that right?
disability.
It would have operated if she'd been posted abroad or got stuck gone on holiday temporarily and then been stuck in that other country and permanently unable to return.
Well, that would
It's
raise
not to do
very
with her.
different issues.
Well, but it's not to do with her characteristics. It's to do with the fact that she ceased to occupy on a permanent basis.
There's a range of reasons for which somebody could cease
But
to
the reason,
occupy.
yes, but they may well be, for example, someone may cease to continue to occupy matters of choice.
Yeah.
That's not what we're dealing with. This
Well,
is a
let's
situation where
I think this is where we're going to have to focus, Mr. Stark, in a moment. But can I just take you back to the aims and the way you characterise the aims here, and look how Lord Reed characterised the aims of the relevant measure in SC, paragraph 60. If you look at paragraph 60. He said the aims of consider the comparability of children and adults in the light of the aims limitation. Those aims can be summarised as maintaining public expenditure on welfare benefits at a sustainable level and requiring adults receiving welfare benefits like other adults to make choices, etc. All right? So it seems to me that if we transfer that approach over to this case, the aims of the legislation are broader than you have suggested. Aren't the aims to take one, to manage the limited housing stock of social housing within the authority's area, and two, to permit, in appropriate cases, those who've occupied the property with the tenant to succeed? The aims. Those are the aims of the measure. And those aims determine the restrictive, the limits of the way in which succession operates under the
well,
statute.
this overlaps with justification, obviously, and this is the point I think Lord Nichols said in Carson, that sometimes it's difficult to answer one question.
Well, you sought to justify this, Mr. Stark, on the basis your submission on the basis of the aims.
You said that was relevant to determining whether the analogous approach.
That's right.
So you can't keep saying it's a justification question. You took us to this in the context of analogous situations.
Yes, my lady, but
Right.
the point that I'm making is the point that was made by Lord Nichols in the Carson case, which is that it sometimes may be very difficult to answer the first question without answering the second.
Well,
The reason why
okay,
I've taken it this way is
you're right about that, but you're right to say that we must follow SC, and of course it's quite a sophisticated argument from Lord Reed, but or just analysis by Lord Reed, but that is where you've taken us, and it seems to me that if you're looking at the aims to determine the question of analogy, you have to look at it not just at the part that you took us to, but to the overall aims of the measure. That's what he is saying here.
Yes, my lord, I don't dissent from that proposition that one of the aims of the succession regime is to limit the number of people who are entitled to
Yeah.
succeed. But very much the way that the Act limits it, or seeks to limit it, is firstly to stop second successors. Secondly, to ensure there is a residence requirement that can be met. Thirdly, that there's a relationship between the people who can succeed. Only spouses, civil partners, people living together, husband and wife, members of the family can succeed, so no one else. Thirdly, that they're living together as their only principal home. Now, the only reason those conditions, those aims of the measure, as I call it, don't apply in this case is because of her mother's status, in the sense that she had to give up occupation and move in to the care home and was not capable of assigning the tenancy. This is where the 1 year is the only period in which, the 12-month period you have to show for that nature of the subsisting relationship. In this case, of course, there was over 50 years that they had been living together from 1965 to 2016. So the aims of the measure is to preserve tenancy for the member of the family who meets those conditions. How is it an aim of the measure that if disability intervenes, they should be cut off and lose all those rights? I say it's not the aims of the measure. It's no answer to say, well, local authorities want to release their housing stock, because that would equally be an answer. And indeed, obviously, if Parliament had decided no one can succeed on that basis, that would be that. Once Parliament has given these additional rights, they have to be dealt with fairly and consistently and without discrimination.
So you say in Lord Reed's phrasing, using Lord Reed's phrasing, that there is no material difference. Looking at the aims of the measure as I have characterised it to be, there's no material difference. Is that right? Between someone who succeeds on death and or assignment on the one hand, and someone who is unable to succeed because of the incapacity of the tenant.
Yes, if the effects of that disability, the broader subset, are that they have to cease to occupy, go into a care home, and they're incapable of assigning. Because in the latter case, if there is a potential remedy, if they did have capacity.
But how is
So
this
if I have to go
argument
into a care home.
consistent about the aims of the measure consistent with the presence of the tenant condition in section 81? Because the tenant condition, you can't have a secure tenancy unless the tenant is in the property, occupying the dwelling house as his or her only principal home. Once that ceases to be the case, you haven't got a secure tenancy.
No, that's not, my lady, how it operates. The Section 81 of the Housing Act is potentially of ambulatory effect, so sometimes people can in fact move in and out of occupation. So long as it can be shown their own occupation as their only principal home at the date a notice to quit expires, then in those circumstances the tenancy wouldn't end. It would still be a secure
Yes, but
tenancy.
on these facts.
Yes, but on these facts, what is the core? I say it is no more, and maybe we're going back to perhaps to a degree to status, but it is no more than what is the reason for the difference in treatment. The reason is she cannot remain and maintain her secure tenancy because of her disability or the consequences of her disability. But one cannot simply just say, well, I say that is in effect similar to the argument that was put, I think in the TP case, that I think I referred to right at the start of today. If I'm going to take you to the TP case, this was the Universal Credit Housing Benefit
Yes.
case.
Can you give us tab number and page number, please?
It's tab 35. Paragraph 92,
713.
and that's on page 735.
Thank you.
An argument about status. So the status identified was a paragraph 89 of the page on the assist, was a severely disabled person who moves to a different local authority area. Mr. Milford submits in both comparative cohorts comprise similarly disabled persons. The differential treatment was not on the ground of their disability or the degree of disability. Further submits Mr. Milford being within one local authority instead of another is not a relevant status for the purposes of Article 14. He submits that a residential address alone cannot give rise to a status within Article 14. We do not accept those submissions. We take the view there's a relevant status in the present cases. The fact of moving home across a local authority boundary can be regarded as analogous in principle with residence in a foreign state, which is recognised as being a status by the Grand Chamber of the European Court of Human Rights. So the point that I make observe in relation to that is the fact that he had to move out led to a move into another borough, led to him losing his entitlement to housing benefit, having to claim a less generous universal credit. And what the Master of the Rolls, I might actually be Lord Justice Singh then says, alternatively, and insofar as necessary, we'd also take the view that status can be said to be that of a severely disabled person who moves home across a local authority boundary. The reason why it's relevant to take into account the fact they are a severely disabled person is it is for that reason they suffer the significant financial loss, the cliff edge. Further, as the facts of TP illustrate, the reasons for relocation by a severely disabled person are likely to be related directly or indirectly to their disability. If they were just any individual who has to claim universal credit by reason of the fact they have crossed a local authority boundary, they would not suffer that significant financial loss. So that's why I say Section 81 doesn't answer the question on itself. It's why it is no longer met.
Thank you. Now, you going back to where the judge dealt with this issue, your submission was that he applied the wrong test and that he didn't apply the right test.
Yes, the test he didn't apply was the aims of the measure test.
He did not apply that
No.
test.
What he applied instead was his concerns about what might happen if someone in relation to the capacity question. So that's what he says in section 188, sorry, paragraph 188 of his judgment. There is this risk of someone losing their rights even if they subsequently regain capacity and therefore could be in direct conflict with their family members. Those might be questions that are relevant to justification, though I've already dealt with them, saying how they just wouldn't work with how the Tickner and Hearn test applies. But they're not an examination of whether or not Miss Mailley is in a relevantly similar position. That you have to look at the factors that we've already addressed.
Okay, thank you. Does that deal with an analogous position? Anything else you want to say
Yes,
on
on
that
this-
point?
on
So are we moving on to justification? I think we're on track to finish at 1. Well done, Mr. Stark. Right.
My Lord, obviously, we're all aware of SC and how that has adapted the test in relation to justification, in relation to the return, so to speak, of proportionality and manifestly without reasonable foundation not being the sole question to answer. But before I go on to what may be, i.e., is it proportionate, one has to first examine, is there a legitimate aim to this provision? That means that someone in Ms Mailley's position would not be entitled to succeed. The first point that I make in relation to that is the Secretary of State was given the opportunity, obviously, to intervene in the court below and chose not to do so. The Secretary of State was also given the opportunity, obviously, to intervene in this court and has again chosen not to do so. So the Secretary of State has not chosen to advance any justification for the difference in treatment, in this case, between Ms Mailley and someone, the comparatives that I've already given in relation to someone who would be entitled to succeed on death or who received the tenancy by way of an assignment. It is noticeable, I say that, for three reasons why that should affect the court's approach to justification. Firstly, the Secretary of State intervened in all of the three succession cases which had previously dealt with questions under Article 14. The Secretary of State intervened in Gangera at tab 14 to advance arguments that the aims of the measure clearly were to cut the number of people who have been entitled to succeed to just one generation.
Sorry to interrupt, Mr. Stark. I mean, aren't some of these points self-evident when one looks at the legislation? And surely this is a question of law. Either it's justified or it isn't. Why does it matter whether or not the Secretary of State pitches up and comes up with an argument?
What the Secretary of State has pitched up in those cases, not just with an argument, with evidence.
Right.
Evidence for the basis of the difference in treatment.
Well, there's a
Why it's
lot of
justified.
evidence here about the scarcity of family houses in this area and the length of time that families have to wait before they are allocated 3 or potentially 4-bedroom houses.
Well, my lady, that doesn't answer the question in this case for justification at all, because that would be a justification for having no succession regime at all. It isn't necessarily a justification for treating someone differently, we would say, in relation to on the grounds that relate to those disabilities that we've referred to.
Do you want to give us the 3 reasons? So the first is the previous secretaries of state have intervened in 3 other cases. In headline form, what are your 2 other reasons? What or
Yes,
significances?
So not just intervened, but have submitted evidence.
Is that 1 or 2? 1A. That's 1B, is it?
Yes,
And
that's
submitted
1A.
evidence, right? Yes. 2.
The second reason, the second point, is then the Brewster approach to how the court considers justification put forward in the case, if no evidence is advanced in support of it.
Right. Do you want to, what's the submission in a sentence?
Well, in Brewster, do you recall, there was a notification requirement for the nomination of a pension requirement from a person who was not living together as husband and wife. And
Yes.
the Northern Ireland government continued with that notification requirement. The effect was that when a man died and they'd been living together as husband and wife, because he hadn't filled in a nomination form,
Yeah.
he did not receive, she did not receive, sorry, the benefits from his pension. It's tab 26.
Okay. So what is the proposition? So
The proposition
you're
then
giving
is-
us the reasons why it's significant that the secretary has not intervened. And the second is because of the Brewster approach, which,
Yes.
yeah. Yes.
It's paragraph 49 onwards on page 431.
Sorry, page number again.
Page 431.
Thank you. Paragraph 49.
Do you know?
Paragraph 49. Question whether justification is demonstrated must be assessed objectively. That's not to say, however, that the court should substitute its view for that of the decision maker. Indeed, it may be appropriate to accord a wide margin of discretionary judgment to the conclusion of the decision maker, particularly where there's the legislation that makes the choice and where the conclusion lies within the field of socio-economic policy. paragraph 50, the margin of discretion may, of course, take on a rather different hue when, as here, it becomes clear that a particular measure is sought to be defended, at least in part on grounds that were not present to the mind of the decision maker at the time the decision was taken. In such circumstances, the court's role in conducting a scrupulous examination of the objective justification of the impugned measure becomes more pronounced. An example of this is to be found in Belfast City Council Misbehaving Limited. What is the position of a decision maker is not conscious of or does not address his or its mind at all the existence of values or interests which are relevant under the convention. The court is then deprived of the assistance and reassurance provided by the primary decision maker's considered opinion on convention issues. The court's scrutiny is bound to be closer, and the court may have no alternative but to strike the balance for itself, giving due weight to such judgments as were made by the primary decision maker on matters he or it did consider. And then paragraph 51 is submissions made by Miss Mountfield. I'm not prepared to accept this submission without qualification. That submission was put by Miss Mountfield is that they should only be given only such weight as their cogency or any supporting evidence warrant. Whilst accepting that such factors could in principle attract weight as a result of particular experience or expertise of the deciding body, she argues the court should not exercise restraint by virtue of the body's constitutional responsibility for taking the decision, because the factors advanced post hoc did not form any part of the reasoning behind the body's discharge of its function. I'm not prepared to accept the submission without qualification. Obviously, if reasons are proffered in defence of a decision which were not present to the mind of the decision maker at the time that it was made, this will call for greater scrutiny than would be appropriate if they could be shown to have influenced the decision maker, and a particular scheme was devised. Even retrospective judgments, however, if made within the sphere of expertise of the decision maker, are worthy of respect, provided that they're bona fide. In those cases that I was referring to earlier, the Secretary of State put in evidence about what was intended at the time, and in the one case, I think it was the Turley case, put in ex post facto evidence about what they believed was intended at the time. But the Secretary of State has put no evidence before us at all for this difference in treatment.
Is there a slight difference in approach potentially in this case? Because Brewster concerned subordinate legislation. So there was a decision maker, whichever Secretary of State it was, who had the power to make the subordinate legislation. We're in this case concerned with an Act of Parliament.
Well, I think, my lady, that distinction was not accepted in Devanshuk, where the O'Donnell, I think was one of the provisions in that case.
That's a very different, quirky point to do with the fact that the terms of the legislation were the same, but the status was different because Northern Ireland is a devolved legislature. I'm not sure one can really generalise much from Devanshuk on that point, if that's the point you're making.
Yes, but that doesn't affect the exercise that one has to carry out in assessing whether or not primary or secondary legislation is compatible with Article 14 is surely the same. And in relation to the fact that secondary legislation is put before Parliament, I'm not sure that I would accept that the court can, in those circumstances, necessarily apply a different test at that stage to the aims of the measure or the justification.
Isn't the court is looking at the primary legislation and seeing if it strikes a fair balance. It's for the court to do that, isn't it?
Yes, and the point that I was making is I didn't think that the fact that there was secondary legislation in Brewster made any difference.
But you don't need evidence. You don't need the Secretary of State to come along and say, we thought it struck a fair balance.
Well, I accept that if it's clear on the face of the legislation and can be easily gleaned from the face of what the purpose is, then that's fine. And obviously, in the other case, particularly, I'll draw the example of the second successors case. They did produce evidence. That was clear on the face of the legislation as to why they were cutting off the second.
So, if it's clear on the face of the legislation why there's a residence condition, why there's a living with condition, why there's a time condition, and the court is able to form a view, you wouldn't need evidence.
But each of those conditions, well, the point that I'm seeking to make in relation to that is that if the court has evidence put before it by the government or the decision maker in these cases, then the court is
The
likely
government's not the
It's-
decision
it's the
maker. The
Parliament.
decision maker is Parliament.
so Parliament. Yes,
Oh,
but the point is that when the court accepts evidence in these cases from the Secretary of State, when the Secretary of State puts forward that evidence, the Secretary of State puts forward in evidence as to what they believe to be Parliament's intention.
But
By
what's the
passing legislation.
relevance of it? Parliament has, democratically elected Parliament has enacted primary legislation. The court has to scrutinise the legislation and say whether it strikes a fair balance.
Yes,
It
but
doesn't
if,
matter what the Secretary of State thinks, it doesn't matter what the government thinks.
Well-
Parliament has enacted the legislation.
well, my lady, that's not been the approach in all the cases in relation to Article 4. Many of these cases, what the court has examined very carefully the justification put forward by Parliament, or put forward by the government on behalf of Parliament for the measure.
So
An SC, for example.
your submission, Mr. Stark, and we've been challenging you, so I want to make sure you get a fair chance to put your submission. You're building submissions on the basis which you started with, the point where the Secretary of State's not here. May have been possibly the wrong place to start this point. Your point is there isn't evidence, no evidence has been put before you by us or before Mr. Cotter, by the Secretary of State or anybody. Secondly, that's more significant, it's particularly significant here because of what the Brewster approach, because we're looking at ex post facto reasoning, reasoning that post-dated, in some respects, post-dated the passing of the measure, which calls for greater scrutiny under paragraph 52 of what Lord Kerr said in Brewster. And there's a third point you want to build. I want to make sure you before we lose sight of it, what's the third point you wanted to make? The third reason why you said the significance of the Secretary of State not intervening. Choosing.
Well, the third point, it takes us on to Baroness Hale's judgment in the Gillam case.
Yeah. Okay. All right. So where?
I won't take you to it now, but also Bruce is helpful at paragraph 64 and 65 in relation to the fact that even if it's an issue of social and economic policy, which I accept this is, the lack of justification being put forward means the court should apply a greater level of scrutiny. Therefore, should look at what justification is. But if we turn to the Gillam,
But Brewster is very different. Brewster was a requirement that you notify the pension authority that somebody was your nominated successor.
Yeah.
And the pay was notified. It's a totally different kind of case.
well,
Anyway,
the
sorry,
one of the major reasons why the court found it in that case as it did was because that no justification had been put forward for the notification requirement.
Okay.
And because there had no justification for it, they couldn't find that there was anything objectively obvious on the face of the legislation, but to justify the difference in treatment arising from the failure to send a notification, when the whole purpose of the legislation was to provide that cohabitees would be able to take their pensions of the people they had been living with. The notification requirement didn't make any difference.
It's. I'm sorry that we're intervening, but you mentioned 60, and I'm sorry, but it's this is a very important part of your case. You mentioned 64 and 65, paragraph 64 and 65 of Brewster. I apprehend they are going to feature quite strongly in your submission.
Yes, we can go back to this.
I'm sorry, it's on page 435. I wanted to give you, I know you're very helpfully looking at the clock, but ultimately the important thing is making sure you get your case across. And I want to make sure you have every chance, Mr. Stark. What points do you want to draw from 64 and 65?
Well, the
of
first point
Brewster?
is the point that decisions on social and economic policy are par excellence the stuff of government, and we accept
Yeah.
that point. But and this is the point that I think in relation to what my lady said, Where the question of the impact of a particular measure on social and economic matters has not been addressed by the government department responsible for a particular policy choice, the imperative for reticence on the part of the court tasked with the duty of reviewing the decision is diminished. In this case, the ENI was not concerned about social economic choices when it decided to mimic the nomination requirement. It was motivated solely by the desire to maintain consistency between the two schemes. Of course, after the claimant's challenge materialised, it addressed possible advantages that might accrue if the nomination requirement was maintained. And as I've said, these are not to be dismissed solely because they're the product of hindsight, nor even because they've been put forward post hoc as a possible justification for discrimination in relation to the claimant's claim. But the level of scrutiny of the validity of claims must intensify, taking account of the fact that claims are made ex post facto and the claimed immunity from review on account of the decision falling within the social economic sphere must be more critically examined. The suggestion that any matter that comes within the realm of social economic policy should on that account alone be immune from review by the courts cannot be accepted. It must be shown that a real policy choice was at stake. While it's not essential that policy options were clearly in play at the time the choice was made, obviously when they were, the cause for reluctance by the courts to intervene is enhanced. In the present case, however, for the reasons given earlier, not only were socio-economic factors not at the forefront of the decision-making process at the time the decision to include the nomination was made, but the attempt to justify retention of the procedure on those grounds was characterised by general claims, unsupported by concrete evidence, and disassociated from the particular circumstances
But
of the claimant's case.
Appellant didn't find that there was no justification for the provision. If you look at paragraph 67, he held there was no rational connection between the objective and the imposition of the nomination. So this isn't a case about justification at all. What he has to say about ex post facto reasoning and all the rest of it is overture.
My lady, I don't accept that because the justification that had to be sought to be advanced in that case was justification for the nomination requirement. And quite clearly he found there was no justification for the nomination requirement and that it wasn't proportionate. It wasn't proportionate or didn't apply to religious domain because the underlying aim was to make sure that people were entitled to take the pensions of the people they had been living with. I don't accept, because he says it's the objective of the particular provisions and the regulations must be to remove the difference in treatment.
Was this passage in Brewster considered in SC?
I've got my gut feeling is that Brewster was cited, but may not have been in the judgment.
Do you want to come back to that after the short? Now, so those are the 3 points you wanted to make arising out of the Secretary of State's non-attendance. I think they're.
And then
we
he
have
wants to go to
those.
Gillam.
You wanted, sorry, those are two. You were now going to Gillam, weren't you? That's right.
It goes beyond non-attendance.
It does.
In a way,
It does. That's how you introduced
Yes.
it. But
I said the
Say
Secretary of
no
State was given the
evidence.
opportunity.
no evidence. No evidence.
No evidence.
Significant. A fortiori because of the need for greater scrutiny because it's ex post facto. And now you're taking us to Gillam.
Tab 33.
Starts on 675.
It's paragraph 36. Paragraph 36, page 687. Maybe I should start at 35. The courts will always recognise that sometimes difficult choices have to be made between the rights of the individual and the needs of society. The second point is, in this case, there's no evidence at all that either the executive or parliament addressed their minds to the exclusion of the judiciary from the protection of Part 15A. While there is evidence of consideration given to whether certain excluded groups should be included, there's no evidence the position of judges ever been considered. There's no considered opinion to which to defer. That leads on to the third problem, which is that no legitimate aim has been put forward for this exclusion. It has not been explained, for example, how denying the judiciary this protection would enhance judicial independence. Of course, members of the judiciary must take care in making public pronouncements to guard against being seen to descend into the particular arena. Responsible public interest disclosures do not run that risk. Indeed, the object of the protection was to give workers the confidence to raise malpractice within their organisation, rather than placing them in a position where they feel driven to raise concerns externally. Just important that members of the judiciary have that confidence. As she says in paragraph 37, I'm going to skip to the bottom there, as no legitimate aim has been put forward, it's not possible to judge whether exclusion is a proportionate means of achieving that aim, whatever the test by which proportionality has to be judged. I conclude, therefore, that the exclusion of judges from the whistleblowing protection in Part 1, 4A of the 1996 Act is in breach of their rights under Article 14, read with Article 10 of the ECHR.
But you accept there is a legitimate aim in this legislation. You've accepted a number of legitimate aims.
Yes, but I don't accept there's a legitimate aim for this particular exclusion. I'm sure there are a number of legitimate aims in the Employment Rights Act for how the Employment Rights Act was drafted and how it was set out. But I don't accept there is a legitimate aim for the exclusion in this case of someone who would otherwise have been entitled to succeed, but is not because of those two reasons that relate to her mother's disability. Mother happened to move out because of illness or disability of assigning. What we say is that there is no legitimate aim, obviously, so why someone in her position should be excluded compared to someone whose mother had capacity. And the background to this, I think, we may have been picked up, perhaps one of my ladies, from the judgment below, was the acceptance by the learned judge at paragraph 168 that this is a position that has changed significantly over time, in that far more people now are dying in care than were at the time the Act was brought into force. And the actual stats from the Office of National Statistics are also in the supplementary bundle that were relied upon below and accepted by the judge. The learned judge gave two reasons as to why he considered that the provisions were justified. The first ones were the uncertainty provisions, issues that he raised also under status.
Yes, we've covered those to some extent.
So I don't propose to address them again. The second reason he gave is one that I say cannot be right. It's at paragraph 197 on page 143. I say on one view, it's also unarguable the case that Parliament has been incrementally working towards reducing the rights of succession to a secure tenancy, having regard to the extreme pressure which is placed on local housing authority housing stock, and the legitimate and pressing need to ensure that social housing is allocated to those who are most in need of it. This is also a legitimate aim. A wide margin of appreciation is allowed to national authorities in relation to general measures of economic or social strategy, and the European Court of Human Rights will usually respect that. It cannot be right, in my submission, to be a justification for treating someone whose tenancy predates 2012 and whose rights are potentially preserved by that legislation as being a justification for treating her differently to someone, for example, whose mother had capacity, that in 2012 Parliament reduced succession rights for a class to which she does not possibly fall.
But what about the general point in paragraph 198?
Yes, but again, it's not in dispute that Parliament has drawn a line as to classes of persons who would be entitled to succeed and classes of persons who are not entitled to succeed. So by removing the second successors and by having those qualifying requirements. What we say is that those general matters in relation to striking a balance do not justify this difference in treatment between Mailley and someone who's, if her mother had died at home, or if her mother had capacity to assign the tenancy to her. This is where the aims of the measure overlap with the justification, because it's not intended that she would be cut out. She would otherwise have succeeded. And it's not any part of that balancing exercise, I say, for her to be treated differently on the
Okay.
basis of her mother's ill health and her mother's incapacity and their consequences.
Right, well, now we've reached 1 o'clock. Without any pressure, how much more? How much longer do you think you're going to take on your case? We've covered a lot of ground.
Yeah, it's only ground 5, which I'd say is about 15-20 minutes.
Yes, probably not even that, but certainly that's all there is left. Plus anything else that may occur to your team over the short adjournment. Thank you very much, Mr. Stark. Look forward to seeing you all at 2 o'clock.